Welcome to all of you guys. Thank you for coming. As most of you know, I'm Lindsay Ernst, and I am here with the Center for Comparative and Public Law, and it's my pleasure today to introduce all of you to Supriya Routh. As I just got, it's pronounced like mouth, but with an R in the beginning. So that's our mnemonic for today. He's an assistant professor of law at the Faculty of Law at the University of Victoria. He was previously assistant professor at the West Bengal National University of Juridical Studies and has held research positions at the University of Laval, Nantes Institute for Advanced Study, and Humboldt University. And I've just found out that after leaving Hong Kong in a week, he will be doing research in Hanoi for 4 months. For 4 months. So if any of you are going through Hanoi, you can look him up. But thank you for coming today, and we're interested in hearing more.
Thank you very much, Nancy. Okay.
Yeah, sure.
Yeah. Just leave it here. Yeah, sure. Well, good afternoon, everyone. Thank you first to Hong Kong University for hosting me. Particularly, thank you, Lindsay, for the introduction, and Alex, thank you for organizing everything with respect to my visit. I'm an assistant professor at the University of Victoria, British Columbia, Canada. I'm going to talk about my university for 2 minutes, and that has a relationship with the talk. So it'll become evident in a moment. So University of Victoria in Canada is kind of a lefty university where both law professors and the students all are aligned towards the left, although we do have some people on the center and right as well. So the idea of a lefty university, as we interpret it at the University of Victoria, is that learning is very student-centered. We care for students, we care for the differences that they come from. If it snows, for example, which it is happening now, if it snows and a student lives far away from the university, we record lectures for those students so that they're not inconvenienced. So, the idea is that it's a student-centered learning place. I'll be talking about migrant workers today. So why I start with that is because I am myself a migrant worker in Canada. I'm originally from India and studied in India, US, and Canada. And right now I'm a migrant academic worker in Canada. In my employment contract, there are 3 things that I have to do as my work. One is teaching, second research, and third service. 40% of my evaluation, my employment evaluation, is on the basis of my teaching, 40% is for my research, and 20% is for service to the university. However, when I arrived at University of Victoria, the first thing that my mentor, every new faculty member is given a mentor, my mentor and several other senior faculty colleagues told me that I'll also have to love my students. Love was not mentioned in my employment contract, but I still have to love my students. That was the first thing I'm told when I was at the University of Victoria. And then I looked at my employment contract. I will not be paid for that loving student. Don't get me wrong, I do love my students. But the point that I'm trying to put forth here is that my employment contract, which compensates me on the basis of my marketable skills, teaching, research, and service, doesn't compensate me for loving my students. So the point here is, if we think in market terms, in market exchangeable skills, market is unable to compensate certain qualities of a worker. And here my concern is care workers. So the nature of work that care workers perform, there is skill in there, but in addition to skill, there are emotions involved as well. I have about 25-30 minutes to give this talk. But normally in a 25-minute talk, the speaker has the audience's undivided attention only for 5 minutes. And I'm told in Hong Kong that normally is 2 minutes. So let me give you the conclusion of my talk in the first 2 minutes, and then I'll take you through how I reached that conclusion. Here is my conclusion. My conclusion is migrant domestic workers in Canada contributes to the society rather than the market. But the logic of regulating migrant work is that by freeing up work at the domestic sphere, they go on to contribute to the economic development of the country, or generally of economic development of the market. My point is then, migrant workers do, or domestic workers more generally do much more than they're compensated for. In order to recognize their actual contribution to a host society, my argument is that they should be entitled to a whole range of citizenship-based rights, at least a whole range of socio-economic rights. Certain privileges, such as voting, could be withheld from migrant workers, but migrant workers, because they go on to create the society in which they live and work, they should be entitled to a range of citizenship rights as a matter of guaranteed entitlement, not as a matter of privilege. So that's what my conclusion is. Now, on the basis of the argument on the nature of migrant work, I'm going to argue that the temporary and permanent dichotomy, or the difference on the basis of temporary worker and permanent worker, should be abolished, and it should not. We should not conceptualize migrant worker on the basis of this temporary and permanent dichotomy, insofar as their legal entitlements are concerned. So that's what my thesis is. That's what the conclusion is. Let me then, in the next part of the talk, take you through the Canadian Caregiver Program and how it brings in migrant workers in Canada, and what are their entitlements and why they are considered temporary workers. And why I chose Canada, except for the fact that I work in Canada. Migrant Care Worker Program, the Canadian Migrant Care Worker Program, is argued to be one of the best migrant care workers program in the entire world, insofar as the breadth of entitlements of migrant workers are concerned. But my argument is that is not good enough. Even though it's one of the best programs, it's not good enough. So let me introduce you to the Canadian Caregiver Program as it is termed now. Just to mention that it's not anymore an in-home caregiver program. It's called only Caregiver Program. The requirement of a worker being in-home is not there anymore. Under the Caregiver Program in Canada, employers can hire migrant workers, and I quote, to provide care in a private residence to children, seniors, or persons with certified medical needs, and when Canadians and permanent residents are not available. So that's the requirement of the Canadian Caregiver Program. They would have to work full-time in private households, which is their workplace. Since 2014, migrant care workers have the option of either living in the household or living out of the household. The earlier requirement was that all care workers would have to live in the household. That requirement is not there anymore. Although I want you to remember that although living inside the household is not a legal requirement anymore, most of the time of migrant care worker is spent within the household because that is their workplace. And also keep in mind the nature of care that they need to provide. They provide care in private residence to children, seniors, or persons with disabilities or certified medical needs. Which means that even though they're not required to stay in-house, they could be called upon any time of the day, and there are flexibilities in labor law that allows migrant workers maximum working time to be 24 hours consecutively. But although there are leave provisions or break provisions if they have to work for 24 hours at a continuous stretch, they'd have to be given substantial leave after that. So the reason why this requirement was changed in 2014 of living out is that arguably this will lead to non-exploitation through excessive hours, unpaid labor, work beyond employment contract, and it would also give migrant workers control over social relations and social contact. It would be an invasion to privacy if they have to live in home. And additionally, there are issues of physical and sexual violence if migrant workers live in the same household in which they work. Although I'm not completely convinced that merely by living out, all of these problems are taken care of, as I'm going to argue. And of course, the other problem that I want to flag at the outset is the problem of inspection and enforcement in somebody's private home. It's always problematic for a labor inspector to come in within a household and inspect how a migrant worker is doing. And this problem becomes even more serious in the Canadian context, particularly in the British Columbian context where I live. In Canada, provinces have their own laws regulating migrant workers. And under the British Columbia Employment Standards Act, the commissioners under the Act, the director, would not suo motu take cognizance of violation of workers' rights. It is based on a complaint-based system. So, and here we are talking about a migrant worker instituting a complaint to a director, and then the entire process gets initiated. And that is seriously problematic when workers do not have significant collective action or trade unionism in their host country. Overall, an employer in a private household would have immense power over migrant workers because in order to get permanent residency, migrant workers in Canada would have to work for the same employer for 2 years, and an employer approves the permanent residency of migrant workers. Before 2014, permanent residency was somewhat guaranteed if one migrant worker, if a care worker stick to the same employer for 2 years or more. But after 2014, that is not a guaranteed outcome. Permanent residency is not guaranteed, it's a possibility. And there is a cap, there is a restriction on the total number of permanent residency granted every year. It's about 2,750 permanent residents are allowed by the Canadian government every year, by the Canadian state every year. So most migrant workers in Canada, like elsewhere, migrant care workers, I'm talking about, or domestic workers in Canada and elsewhere, are Filipino workers. Now, I'm not going to spend substantial time on arguing this, but a part of the overall justification that I'm arguing is what Canada is doing here is moving their obligation onto Philippines, in the sense that Canadian government cannot completely reciprocate the contribution that migrant workers make to the state. They're moving part of the obligation in compensating those migrant workers over to Philippines, wherein relatives and other next of kin of the migrant workers take care of the migrant workers' children and other relatives back there. So Canada is transferring their obligation internationally to the Philippines. And that's an argument I could respond to during the discussion, but I'm not going to spend a whole lot of time on that. The logic would become clear to make that connection in a while. So, the nature of working relationship when, as per the Canadian Caregiver Program, when a migrant worker comes in Canada, the nature of the working relationship is private employment relationship between the employer at whose home a migrant worker works and the worker. It's a private employer-employee relationship, and that's how the relationship is regulated, wherein workers could claim certain rights, certain entitlements against the employer. So that's what the justification is. And hence, legal rights flow from that private employment relationship. And insofar as, and I'm talking about British Columbia Employment Standards Act, and generally all the other provinces' employment standards are similar. British Columbia is quite harsh in certain respects, but normally it keeps up with the rest of the provinces. So normally no discrimination exists between Canadian and migrant care workers. If a Canadian is performing care work and a migrant worker is performing care work, they're both entitled to the same rights and privileges under the law. However, this is kind of funny. The Migrant Caregiver Program exists because Canadians and permanent residents do not want to do this work. Yeah. So all these provisions really apply to migrant care workers. So there are entitlements pertaining to wages, modified maximum hours for care work, overtime payment, leave provisions, and so on. As I've already mentioned, the any dispute resolution mechanism is complaint-based. If there is a dispute claimed by a care worker, they would have to institute a complaint. For workers other than care or domestic workers, there is another thing that workers need to do. They'll have to fill in a self-help form and try to conciliate with their employer before instituting a complaint.
Just among themselves?
Just between the employer and the employee. I know, it sucks, really. And it's kind of a provision where you are complaining against the employer to the employer.
Yeah.
And they're not going to call you back if you do that. Although that provision is not applicable to migrant domestic workers, but it's there for migrant agricultural workers and all other categories of employees. That provision exists. Migrant domestic workers, however, are exempted from that requirement. They can institute a complaint directly to the director. The other reason why migrant workers their entitlements are temporary is with respect to unemployment insurance, their general awareness of their rights and how to institute these complaints, and overall absence of collective action. Apart from all of these, think about the way law and legal dispensation, justice dispensation works. In order to resolve the issue, one would have to first institute a complaint to the director. If the order is unfavorable, they would have to appeal it to the tribunal. From the tribunal, only on certain grounds, administrative law grounds that some of us are aware of, there could be an appeal to the superior courts. And finally, by the time it goes to the Supreme Court, it would be about 5 years. And these are migrant temporary workers I'm talking about. So the entire mechanism of doing the thing treats migrant workers as temporarily entitled to certain provisions. And many of these provisions they cannot realize because of the nature of working of the legal system. Okay, so what is the general regulatory rationale of protecting migrant workers? Why would law protect migrant workers? The scholar Ruth Lister pointed out that migrant care workers are, I quote, providers of welfare rather than recipient of welfare. Thing is, they are providing welfare to Canadian society, and if I could take the liberty, to Hong Kong society as well. But they are often treated as would be dependent on welfare if they're not sticking to one particular employer. And their work is unique, and the International Labour Organization recognizes that. Now, there are two things that I'm going to talk about in assessing regulatory rationale of migrant workers. One is unpaid care work done by mothers and wives and sisters at home and daughters at home. But the other part is paid work, and that is what is done by migrant care workers. Now, I'm going to argue that in a market-based framework, employer-employee relationship, paid care workers are not fully compensated as they should be compared to their contribution. And unpaid care workers are not at all compensated by the legal regime. Let me start with the ILO position. Now, why there needs to be a regulation on migrant workers' rights? In 2011, the International Labour Organization promulgated the Decent Work for Domestic Workers Convention and Recommendation. It recognizes centrality of domestic work for economic productivity. It adopts a human rights approach in addressing marginalization and insecurity of domestic workers. One of the principal contribution of this convention is that it recognizes home as a workplace, private home as a workplace. It offers a market-centered justification of economic productivity in recognizing the value of work. The preamble of the convention says the convention seeks to overcome the vulnerability of paid domestic workers who significantly contribute to the global economy by offering standards specific to domestic workers. So if we accept the underlying logic of why domestic workers' rights needs attention, why their right needs protection, the argument is that because domestic workers contribute to the economy. How do they contribute to the economy? Domestic workers, by doing domestic work, frees up other market participants' time so that they could participate in the market. Secondly, by caring for others, say children, domestic workers are also creating workers for the future who would later go on to participate in the market. And under both of these situations, the argument is that these workers whose time domestic workers are freeing up, or who domestic workers are creating or create labor power, because of their contribution ultimately to the market, domestic workers should also be compensated. Right. I think it's problematic argument. I'll come there. But in addition to the ILO is talking about paid domestic work. There are certain feminist scholars who follow the same line of argument in order to think about unpaid care work. Now, generally, feminist literature identifies three kinds of social reproduction. Biological reproduction, second, reproduction of labor power, and third, social practices of caring, socialization, and fulfilling a broad range of human needs. When they're talking about attributing economic productivity to domestic work, they're primarily talking about reproduction of labor power. However, I'm going to argue that this labor power, if we go on along the same line of argument of economic productivity, also co-ops, integrates other components of social reproduction, such as biological reproduction and social practices of caring, socialization, and fulfilling a broad range of human needs. Political economist Antonella Piccio says, and I'm quoting, "The reproduction of the working population has to be considered a necessary input of the productive process. In addition to its overall contribution to the standard of living, unpaid work sustains the filtering process of the labor market. In this case, the unpaid work done in the home serves to underpin the selection of individuals for the labor market and the personal capacities used." She further notes, housework is the production of labor as a commodity, while waged work is the exchange of labor. To be exchanged, labor must be produced, and to be used in the production of other commodities, labor must be produced and exchanged. And it's the same argument, elaboration of the same argument that I just mentioned. Adele Blackett, an influential legal scholar who also contributed extensively to the ILO Convention on Domestic Workers, she notes, she is a wonderful person, by the way, but I have issues with what she says. She notes, domestic work is valuable because it ultimately contributes to market productivity by producing future market participants. Judy Fudge, and she was my PhD supervisor, and I also take issues with her. She says, dependent caretakers are part of the system of production and they engage in household production, producing workers of the future, even though they may not be directly paid through market exchanges. Now, at one level, my critique is that this is very disrespectful of domestic workers if their compensation would be dependent on their indirect contribution to the market. So it's not recognizing contribution of domestic workers, rather the workers who are actually participating in the market who domestic workers cared for. It's a very indirect logic to their economic contribution, and that to me is disrespectful of the workers themselves. Second level, why it's problematic is, well, domestic work, let's give you a stark example. When a domestic worker is caring for a child, and the child falls off, the skill part of domestic work is bring in an antiseptic, apply it at the place, and then stick a band-aid or something on there. But as soon as a child falls off, the first reaction of a domestic worker would be to run towards that child and pick it up. That is not part of the skill, that is part of the emotion, that's part of the love in domestic work. If domestic workers would only be paid for skill, the skill is to application of antiseptic and putting on that bandage without any expression. Pick the child up like that, throw it on a bed, and then put it there. That's the skill I'm talking about. But I don't know of any domestic worker who does it that way. The first reaction is always running, caring for that child. So, market pays, they are doing both, and that is exactly my argument is in here. By linking domestic workers' contribution to market productivity, what these feminist scholars and the ILO is doing is conceding the justificatory ground to the market. So if you say domestic work is valuable because it contributes to the market, now it is in the market who will decide how much to value domestic work. That I think is problematic. So what is happening in there, and then the market decides what is a worker. Increasingly, market demands more humanistic and trustworthy workers. Market increasingly demands humanistic, social, cultural, linguistic, and emotional qualities from workers beyond their mere skill set as workers. As I mentioned at the very beginning of my talk, I'm paid for my skills of teaching, doing research, and providing service to the university. Love was not mentioned in my contract, but that's the first thing my senior colleagues told me when I arrived at the university. So I'm expected to bring in love, but I'm not paid for that love. However, the argument is, market is a place of exchange, a private exchange. It is not a place that could take cognizance of love. And the last time when I checked the definition of love in my mother's language, it says that it could not be exchanged. And then I checked again the definition of love in the Queen's language, and I found it's quite similar as it is in my mother's language. So love, by very definition of it, is not an exchangeable commodity. But every domestic worker, every teacher, every professor do bring in that emotional component to their work. And the market is unable to compensate for those emotional components of work. If the justificatory ground is given to the market will say a worker would also have to bring in love alongside their skills. I urge you to look at British Council study called Culture at Work, the value of intercultural skills in the workplace. It's easily available in website. There are some other scholarly articles such as The Managed Heart, Commercialization of Human Feeling in the Production of Reality. Jonathan Payne, Emotional Labor and Skill, a Reappraisal. Antonio Argandona, Beyond Contracts, Love in Farms. And there are a plethora of other writings wherein market increasingly want emotionally equipped workers in addition to have their skills. So if you give the justificatory ground to the market decides how much to compensate and what qualities to require. So the market is ill-equipped to take cognizance of the emotional components of work. What happens then? I am not denying the existence and importance of market. It is important. and markets might be able to take cognizance of the skills of domestic workers. But markets are not a place that can take cognizance of emotional components of domestic work. So here, the society or the state needs to intervene. So when I'm talking about the state, I'm not only talking about the government. I'm also talking about opposition parties in parliament. I'm also talking about commissions and committees that are part of the state. I'm talking about legislatures as well. So all of it, this integral body is the state. And I'm also talking about non-state entities such as civil society in order to integrate in this process. If the state needs to take care of those components of care work that are not valued by market, and here my stark example is, if migrant care workers were not contributing to the Canadian society, and if Canadian children would end up becoming drug addicts because there was no supervision of these children when they are growing up. In Canada, marijuana is legal, by the way. Now, so if they all end up becoming drug addicts, that's not a good news for the society. So it's not that by focusing on the emotional components of work, I'm trying to undervalue the emotional components. For me, those components are far more important than the skills migrant workers bring to, migrant domestic workers bring to the society. In order to take cognizance of this socially necessary work, which is sustaining and furthering human lives, families, and social well-being, but they are not directly productive through a market-based private exchange relationship, the state needs to provide, and my reference point here is the Canadian state needs to provide a full range of citizenship rights with guaranteed permanent residence in Canada for the migrant workers that come and contribute to the host society of Canada. This logic that I'm offering is a public relational component of care work, and I'm arguing that all social and economic rights that are available to Canadian citizens should immediately be available to migrant workers on their arrival to the host society. However, certain rights, such as voting, could be withheld from them unless and until they become integrated into the society. They understand the political process, they know the political parties, and they know the orientation. It could be there are grounds to withhold voting rights or rights similar to that. But with respect to socio-economic rights, all the rights, bunch of rights should be immediately available to migrant workers on their arrival with a guaranteed path to citizenship. I will conclude then with the two claims that I'm making in this paper. Claim one is that foreign migrant workers performing care work cannot be considered temporary insofar as their socio-economic entitlements are concerned. And claim two, the entitlement approach of migrant workers has to be labor rights plus approach. So something in addition to labor rights, existing labor rights. That should be decentralized on the basis of experiences of migrant workers. Because if you apply the same kind of labor rights to migrant workers and domestic workers and citizens, worker citizens, what happens is migrant workers' experiences, their situated living is not taken care of by the same bunch of rights. In order to actually give them equal amount of entitlements, rights and entitlements would have to be shaped by lived experiences of migrant workers. I will stop right there. I might have gone a few minutes over my time, but I'll stop right there and come back to some of these issues if there are questions. Thank you very much.
Thank you. I hope that you went over your time. Okay, it had to be again. Any questions? I have lots. I'll let you guys see first. Question?
Example, what if example for me, if I'm going there and then I be terminated with my employer, I will be going back home, or I can stay there to find another employer.
here, domestic workers can only stay in Hong Kong for 2 weeks if they are terminated in their contract, or they have to leave. And so great question, because this was one, so what happens in Canada when you say, like, that there's this legal system set up, but the entire mechanism treats migrant workers as temporarily able to avail themselves? If a migrant care worker is terminated, how long can she or he stay in Canada?
Well, now there is an option for them to find another employer.
But I need to go back home.
So what's
No.
the time range? What's the time range from termination to finding another employer?
I'm not sure of the exact time range, but if a worker is terminated from their work, from their care work, they are allowed to find another employer who needs a migrant worker. But there are conditions attached to it in the sense that they would have to find another employer. The assistance could only come from, say, the civil society, or if there are organizations working with migrant workers, they are only allowed to assist. Earlier, they would have to go back home because they were tied to one employer. But now, upon their termination, they could find another employer and still stay in Canada. But there's always this requirement that one would have to work for an employer for 2 years in order to qualify for permanent residency. So if someone's service is terminated, the time starts again of the 2-year time.
Yes.
So migrant workers try to stick with the same employer as much as they can.
So, but then again, you also mentioned that it has to be approved by the employer, when applying for the.
Yes, there needs to be a certification from the
Certification.
employer that they work for 2 years and there are no.
Oh, it's just the certification.
It is a
Ah, okay.
certification. It's not an employer approval. Approval
Okay.
in the sense that
Yeah,
approving of their
That's
behavior or
Yeah, for 2 years.
their-
Okay.
yeah.
Just proving that you stayed there.
Right. It's more in the sense of a recommendation letter rather than I approve them
Yeah,
to
yeah,
have
yes,
permanent
yeah.
residence. It's not on the employer totally.
So then before that permanent residency, if I understood correctly, you're saying that I am not entitled to the rights of the locals?
You are entitled, a migrant care worker is entitled to the rights of the local workers insofar as
To
it
a
is provided
certain,
under
certain
the law.
points. Yeah.
So if the law gives certain rights to domestic workers, it is the same for citizen worker and non-citizen worker. That right is same. However, how you realize that right is problematic for migrant workers. The realization, one is the nature of the court system, nature of the complaint system is problematic for migrant workers. And there are scholarly studies on each one of these aspects. One is awareness is a big problem, that they don't even know what their rights and entitlements are. Second, it's a complaint-based mechanism rather than a proactive investigation. So no migrant care worker would like to institute a complaint against their employer, which means that they would have to find another employer if the employer with whom they're working is not satisfied with
Yeah,
the complaint process.
especially for us Filipinos, just like here.
Absolutely.
We'd rather not complain because we'd lose more than we gain.
True. And that is one of the, that's a reason of temporariness. Not a formal reason. Formally, legal rights are same for citizen worker and migrant worker if they're doing domestic work. But as I said, citizen workers do not want to do domestic work.
Yeah.
Hence the existence of the caregiver program itself. So by not discriminating, the law ends up discriminating between citizen workers and migrant workers.
So I know Jenny has a question, but I'm stepping in for 1 second on this comment, because when you say by nature the law discriminates, because the migrant care worker contract in itself is not maybe great protection, but to me, that's where your argument of, fine, they don't need voting rights. I actually think they need the voting rights, because they have no voice to change that law, because
I concede that. I think one could argue that they perhaps need voting rights, but part of it is
Give something
strategic.
away.
Exactly. And part of it is strategic, that I don't want to say that treat them like citizens from the very go. Nothing is going to happen if I do that kind of undertake that kind of an approach. I take your point, and it's a valid point. Although my more academic reasoning is the following: that people should be entitled to voting rights when they can make sense of the political process and understand the political positions. So the day you arrive in Canada, irrespective of migrant worker, academic worker, whatsoever worker is that, until and unless they understand the political process, until and understand they engage in that informed opinion, participate in that process, I think there could be reasons to argue that certain rights could be withheld, such as electing representatives. But yeah, I don't take the issues if you critique me.
I like your advocacy point on that too, 'cause it's not a good advocacy conversation of voting rights right off the bat. But Jenny.
You mentioned about the time frame that it might take to bring a case in courts.
Right.
If a migrant worker did bring a case, is there any support offered to them? For example, I mean, if they had a case against their former employer, they might find it difficult to get another job. But would there be any support available to them in terms of?
Not officially. The support comes from civil society, not from the state. So the state support is restricted or limited only insofar as providing pro bono services. So that's the extent of state support. But if they're successful, they can realize all the costs from their employers. But as you rightly indicated, it becomes very difficult for them to find another employer, because all the employers would know that this worker has instituted complaint against one employer, and there is no guarantee that they would not do it against another employer. So the perception problem is always there. Also, to add to that, because that's such a good question, scholars such as Catherine Duvern studied 30 years of Canadian Supreme Court's judgment on non-citizens, how Canadian Supreme Court engages with non-citizens, and she showed that Canadian Supreme Court has not been really favorable to non-citizen workers initially. It's only quite late, say this decade, they are increasingly trying to see migrant worker point of view, but the Supreme Court has not traditionally been very supportive of non-citizens' claim in Canadian Supreme Court. So, yeah.
One more question.
Yes, please.
You mentioned that the law in terms of the live-in, what we call here the live-in rule, was changed. Do you know what percentage of workers now live in or live out?
I don't know the exact percentage, but I'm not even sure if there are studies that actually identify that. But I read newspaper reports that says that most workers still prefer to live in
Yes.
with their employer.
I wish you
But
would
I
do a
can't
study on that so we
Right.
can use
Yeah,
that
that
in
would
Hong
be
Kong to
really
get the law
interesting.
changed.
Yeah. I'm hoping a sociologist will
Do that? Okay, for we have two questions, Sebastian, and I don't know your name.
In Canada, what are the sort of protections and entitlements available to migrant workers who become pregnant, and then also the child who comes out of that?
When you say protection, what exactly do you have in mind? Is it labor rights protection? Is it immigration rights protection? Because these are the overlapping.
Well, sort of both, and then where does the child stand in terms of their sort of residency rights?
Right. Unless and until a migrant worker is a permanent resident, the child would have to be registered at the embassy where they come from, where they come from. But if the migrant workers are permanent residents, then the child becomes Canadian. Insofar as labor right is concerned, workers cannot be terminated because they're pregnant. And they should be entitled to unemployment insurance, and employer would have to continue that. So there are substantial legal restrictions on it. However, as some scholars noted, that sometimes these legal provisions are violated with impunity because migrant workers are not aware of their rights. They perceive and they are given to understand that when they become pregnant, their time as workers are done. So they arrange for themselves to go back to Philippines, for example, rather than staying back and asserting their rights. So it doesn't go on all the way to the tribunal or the director under the Employment Standards Act. However, legally an employer is not permitted to discriminate when a worker becomes pregnant. And that's the formal equality of the law, and no Canadian worker could be terminated when they're pregnant. And there is the Human Rights Code that overrides all other legislation in all the provinces. So, and this is a human rights issue. Recently, not with respect to migrant care workers or domestic workers, when the Vancouver Olympics were happening, workers from Latin America and Europe were brought in Canada to create the Canada line, the SkyTrain. And Latin American workers were paid much less than European workers. The argument was that European workers need more space, better food, but Latin American workers were in any case earning more than they would have done in Guatemala or Mexico. So it was then found by the court that it's a violation of the Human Rights Code. So likewise, I would think that any pregnancy issue would be a violation, if a worker is terminated, would be a violation of Human Rights Code. However, to end the story on those Latin American workers, when the tribunal allowed $2.5 million in favor of the Latin American workers, there was an out-of-court settlement of $1.25 million between the workers and the employer. So the temporariness intervenes at every stage of the process. Yeah. Even after a judgment of $2.5 million, it was settled for $1.25 million. And the Mexican workers were elated to have those $1.25 million, saying that I will buy a car now, without complaining that why it's 1.25. Well, they don't get invited next year if they're not accepting the settlement money offered by the employer, right? So it's layered, but there are formal protections with respect to pregnancy. Canada is a nicer state than the United States or some other. So they wouldn't throw out the child in that sense.
And
so,
in terms of the 2-year requirement to get residency rights, if you take maternity leave as a female foreign worker, is that sort of time put on hold while you're on a maternity leave and then resumes when you come back to work?
It's a leave. It's an unpaid leave, and you are on unemployment insurance.
Okay.
So that.
So you start again.
No, not starting again. It'll be suspended. So the say 4 months, 5 months, 7 months, however time is that one is not working, that would be subtracted from the overall number of years.
So you mentioned that it's unpaid leave. So is there no paid maternity leave?
Well, the payment comes from unemployment insurance.
So it doesn't go to the employer?
No.
Okay.
But although for the first 3 months an employer is mandated to contribute to insurance, but once a foreign worker qualifies for state insurance, then the employer wouldn't have to do that.
Sorry, and so how long is maternity leave?
It ranges from, I think, 1 year to a few weeks. So it depends on the worker how much leave they want to do.
Okay.
So,
Sitting behind you, Jane, she's so nice.
Thank you very much for your talk. So I would like to ask a practical question. What do you think can motivate the state to take the steps that you have suggested to give migrant workers more rights? Because I understand why they would most advocates would focus on the productivity aspect is that this is a kind of reasons why the state would accept the enhanced productivity of the market. So what would motivate the state to take steps further than that to give them the wider range of economic social rights?
shame the state. Shame the state, tell them that you're taking advantage from these workers without paying them enough. In a democracy, that works very well. Shame, or one would say, generate political pressure. So what I'm doing is I'm shaming the state, but what I expect civil society to do is to exert pressure on the state that these are real advantages that you're gaining from domestic workers, but you're not paying for these advantages. You are channeling your obligations all the way to Philippines, and you're only taking advantages. So generate political pressure onto the state, and normally in democracies it works well. I don't know how it might work in China. So,
Or here.
yeah. However, or Hong Kong. However, one thing I find super interesting is even when totalitarian regimes are suppressing protests, their argument is there is no protest. People are with us. I have not heard Nicolas Maduro say, or the Chinese state, say that these are the bourgeoisie. They will protest because they're against us. I haven't heard any state say that. Everyone is saying it's just a small minority, people are with us.
Yeah.
States need to show that people are with them, even in totalitarian states. I haven't come across any argument where a state is saying these protests are bourgeoisie protests and we are proletariat government. No state says that anymore. So the idea of shaming the state, generating political pressure onto the state, I think appeals to even in totalitarian or one-party states. So that is, I don't know what other ways to go on to convince the state.
So I get one more question.
You had several questions listed up. You told me.
You can see them all listed over there. I'm curious if you draw a correlation, and I'm wondering what the rules are in Canada about when a domestic worker or migrant worker comes over to Canada, can they bring their family with them at any point? And after they get residency, can they bring their family with them? Because I'm wondering if there's any correlation when you talk a lot about this emotional quality, and we put this investment in you need to raise my kids, and we're going to see your social value as raising my kids. Is there a connection between not allowing migrant domestic workers to bring their families and this emotional quality that we seem to demand?
That's a great question, and I do mention it in the paper, although I haven't talked about it. Migrant workers are allowed to bring their family when they have permanent residency. They're allowed, but there are practical again problems because in order to bring your family, there are educational requirements and there are financial requirements. A migrant worker would have to satisfy not only migrant worker but also some members, close members of their family would have to satisfy educational requirements. They are educated up to a college degree or whatsoever, and they would also have to show financial sufficiency so that all the entire family that is brought in is not dependent on state welfare. So that's the logic behind it. And I think, although I do not explore that in this paper, I think there is a great paper hiding in your question, looking at how this emotional component is transferred to the family and what role the family, bringing in the family and not bringing in the family, what difference does it make to this emotional component of domestic work? So I think there's a great paper hiding there.
Yes, Debbie.
Thank you for your presentation. I just want to ask whether there is some research done in Canada in terms of looking at the way the court seeing a case lodged by migrant workers and the court decision on other non-migrant workers. Because I mean, from the glimpse of like district court and things like that, when I look at it in Hong Kong, it seems like there's this discrepancy in terms of like punishment when penalty when an employer failing to pay wages if it is a migrant workers and if it is a commercial employee. And I wonder, people might argue this is the judge privilege, but I wonder whether there is a systematic research has been done to see whether a judge has been consistent in terms of handed out a sentence for non-payment of wages in Canada.
like whether one judge has been consistent or the court has been consistent. Is that what the question is?
Any, like.
Right. I haven't come across any study that identifies how a court behaves with respect to migrant workers and with respect to citizen workers.
Yeah.
But at the end of my talk, I mentioned a study that a scholar from UBC did on the Canadian Supreme Court, identifying how the Canadian Supreme Court approached the question of non-citizens' rights in Canada. So what she found in her study of 3 decades of Supreme Court judgment is that initially the Canadian Supreme Court has not been very sympathetic to non-citizens' rights. They have tried to, they did not allow non-citizen rights in Canada, but increasingly the court recognizes the fact that non-citizens do have certain rights in Canada. Particularly in Supreme Court judgments, at least in labor, since 2012 to 15, there has been increasing recognition of non-citizen workers' right to form trade union, unpaid wages and conditions, living conditions. But these decisions pertain mainly to agricultural workers, not domestic workers.
Thank you. Any other questions?
Yeah.
Yep.
With regards to the complaints, you said, you mentioned it's complaint based. So is there a certain number of complaints before something is going to move on, or one complaint is enough for?
One complaint is enough. So it's a layered process. So under the Employment Standards Act in British Columbia, so a domestic worker would have to institute a complaint. If there is a problem between the worker and the employer, she would have to complain to the Director of Employment Standards. The Director will, in their discretion, judge whether the complaint has some basis or not, then accept or reject that complaint. So once the decision is given, they could reconsider that complaint, then it would go on appeal to the tribunal, Employment Standards Tribunal. But from the decision of the tribunal, if there needs to be any appeal, it could be only based on mistake of law or some other problem, error in judgment, or some problem with the judge. So very limited ground appeal is there. But every complaint would be taken note of by the Director. But this is only with respect to domestic work.
Yeah. So it would be taken note of, but not necessarily really moving forward, because it's the Director's
Yes.
discretion whether there's a probability or not.
Absolutely. That's
So,
right.
but then now, where do I stand in there? What are the evidences again that I need to, bring along so that then the Director would do something about it?
Right.
Because I can just be,
Hanging in
maybe
between.
I can just be, taken advantage of, because,
True.
okay, I complain about my employer, I am the migrant worker, this is a citizen here, and just like you've mentioned, in the last decade, they are now a bit more favorable with citizens, so where will I stand?
Not in a very good position.
Exactly.
Yeah. So one thing is, your question partly is on what evidence you need to bring in. That is very situational, so I cannot comment on that, I cannot analyze that. It will depend on the context, what evidence is required. But you have rightly pointed out that the Director is free to reject a complaint. There is one provision in the Employment Standards Act that says, just because a migrant worker complained, there cannot be a discrimination by the employer against that migrant worker. There cannot be a retaliatory action by the employer against that migrant worker. But again, it's a formal law. But the system is based on freedom of contract, individual employment relationship. So if the employer doesn't like a migrant worker, they can give 3 months notice and terminate services of a migrant worker. And they can argue that this is not a retaliatory action, although there are
yes,
other criterions of the courts, such as balance of probabilities. There are criterions by which to judge. But what I'm suggesting is there are processes to subvert what the law says. So there is always those possibilities.
So then, I'm just being too negative, okay? So again,
You have reason to be negative.
the director of the complaint, then this person would actually have the right to be in a position to discriminate me if sometimes they would just think that he did not take my complaint because he discriminated me.
Sure, if you have that feeling, you can go on to the human rights tribunal. It is complicated, but a director is not entitled to discriminate. They have discretion. Discretion is not discrimination.
Yeah.
Discretion is the way you are supposed to act,
Yeah.
not at your whims.
Yeah.
That's the role of the director. But if one feels that the director has been discriminatory, they can complain against the director. And this has happened in Canada. In 2017, December, there was a case instituted against the Human Rights Tribunal, that the Human Rights Tribunal wrongfully intervened in a dispute between two co-workers where one co-worker discriminated the other co-worker. Supreme Court had taken up this decision and reversed what the tribunal said, and saying that yes, Human Rights Code applies also between co-workers. So, and that decision, the name of the case is Schrenk versus British Columbia Human Rights Tribunal. So it was a complaint against the Human Rights Tribunal. So if a worker feels discriminated, they could challenge the director and the tribunal itself.
At the risk of Alex not letting me moderate another panel, I'm going to try and end on time. Because I'm horrible at letting my class end on time. I'm only 5 minutes over. I feel better than normal. Thank you very much. I think that you clearly had attention for more than 2 minutes, which is very well done for Hong Kong. And I hope that you will come back and stay for longer, because I think there's a lot of area, as you've seen from the questions, there's a lot of room for research in this area in Hong Kong.
Mas mahirap.
Thank you guys for